The cover-up was done to advance what we in the legal profession, we call it the state-of-the-art defense. And what the state-of-the-art defense kind of means is that companies can't be presumed to have knowledge that hadn't been developed yet. A moment ago, I mentioned electron microscopes, and if they had had electron microscopes, they could have known A, B, and C. Well, we can't hold Johns Manville accountable for not having an electron microscope in 1933. A good way of explaining that was actually done by their corporate defense attorney in a letter to them. We have a letter sent on December 15th of 1934 from the defense attorney that settled those asbestosis cases to Vandiver Brown, the corporate attorney. And it said that one of our principal defenses and actions against the company on the common law theory of negligence has been that the scientific and medical knowledge has been insufficient until a very recent period to place upon the owners of plants or factories the burden or duty of taking special precautions against the possible onset of the disease to their employees. What he is saying here is, we didn't have this knowledge until very recently, so courts can't hold us accountable. We can't be held accountable for something we didn't know. In one of the earlier videos, we talk about Mr. Henry Ward Johns, the founder of Johns Manville. He himself died of asbestosis in 1898. Now, we can't hold him accountable in any way. He didn't know, right? He had no idea this stuff was dangerous, so no one else in the company did. But Mr. Hobart here is writing to Mr. Brown explaining that as we get more knowledge, the law will put more duties and burdens upon us to protect our employees. In other words, knowledge of the hazard is the most important part of this conspiracy. What can they hide from their own knowledge? If they don't know it, they will not be held accountable for not knowing it.